IP, IP,
IP,
IP, IP,
IP,
IP,
IP,
IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys. Now, before I get into our story for today, if you haven't listened to the last 107 episode, Ejo Biko, please help your girl. Just help me. But yeah, earlier this month, Maxi Combe, who is my mentor of life and a source of inspiration, tagged me on a post after he had shared the link to the story involving Coca-Cola Nigeria being asked to pay compensation or damages of 3 million naira, which is equivalent to $4,000 based on our exchange rate. And he was like, "At Amri, I await your usual masterpiece, the section of such trendy IP news." And then it was like, oh my god, and this is like the second case that Max is actually drawing my attention to. So I decided to take my time. And do an in-depth research about the case. What is it that every other person is really not focusing on? And I read up two things. First is, while copyright might be like the prevailing IP to discuss, there were other salient issues that were raised in the course of the publication that I've come across, not seeing the judgment. So my research and my response to Max's request is based on what I have seen in the public domain. So the second one is breach of confidence. And one thing that struck me is that these two type of IPs basically enjoy some sort of automatic protection from the moment it's created. You know, while breach of confidence might transfer obligation to the person receiving it to take extra precaution to protect the information. Come on, copyright is just there. I've created it, I've put it out there, and they're kind of like a bit more vulnerable. So what this tells you then is that as an IP owner, whether as a creative or an inventor, you need to explore multi-tiered IP protection. Then after I had shared the carousels on LinkedIn, I got a comment that, apologies guys, I got a comment from Aban Miracle, and it also kind of made me, I was going to look at it in passing, but when he asked me the question, I decided to take a second look at it, and the question goes towards so it says, it's a very clear case of IP infringement. My concern is what would be the procedure of calculating the profit made from the use of the calendar in their publication. Now, if you go through both the old Copyright Act and the new Copyright Act, it wasn't expressly stated how you can do that. I just feel that as an IP attorney, what you may come up with is just to have like a smart IP strategy by either relying on, under the new law, you're relying on the four-factor formula and the non-commercial purpose test, which is whether it was for private use and whatnot. But yeah, let's get into our story. Headline news: Court orders Coca-Cola Nigeria to pay 3 million naira to Onilemarun for copyright infringement. That was it. And I was like, okay, let's take it. So the story goes that the young man in question had, at some point, maybe they had some sort of discussion, about the calendar work in the Ramadan timing for dawn meals and breaking of fasting in Kwara State sometime in 2014 and 2015, or maybe prior to that. But the infringement took place afterwards, and it was the timeline was between 2014 and 2015. And per usual, every creative will be first upset, which is like the initial reaction, and they decided to seek the opinion of their lawyer, who eventually filed a lawsuit against Coca-Cola and Nigeria Bottling Company (NBC), and they asked. So some of the others or the relief they sought was first is an award of damages of 10 million naira against Coca-Cola and Nigerian Bottling Company (NBC) for the unauthorized reproduction, publishing and distribution of his copyright work in the Ramadan timing for dawn meals and breaking of fasting for Kwara State in 2014 without his consent, license, or an assignment. And we know that when you're talking about intellectual property, without any of these things, you are alleged to be infringing on someone's creative work or inventive work. Second, they're asking for an account of profit that Coca-Cola and NBC had made between 29th June 2014, 28th July 2014, and 17th June 2015, and 16th July 2015. And I think this is what attracted Aban when he asked me that question, and we're going to get into it. Thirdly, they were asking for an award of damages of 10 million naira against Coca-Cola and NBC for breach of confidence of secret information and secret ideas. So I'm just going to pause there. Ideas do not enjoy copyright protection. Ideas do not enjoy intellectual property protection. Let's get that in out of the way first before we start going. But yeah, he accused them for breaching the confidence he had in them when he shared his um, Ramadan timetable with them. So he's accusing them of using that information to produce the Coca-Cola Ilorin Ramadan timing June/July 2015 um, by way of unlawfully reproducing, publishing substantial similarities of his work. So his work in question now is the Ramadan timing of dawn meals and breaking up fast for Kwara State in 2015 without his consent. And I mean, for someone to sit and even think of something like that, it just shows that the person has put in a lot of effort. He has thought about it and like, how am I actually going to make a difference in this religious time? Next, he was asking for an order sharing to him. Another sharing profit of 40% made by Coca-Cola and NBC between 29th June 2014, 28th July 2014, 17th June 2015, and 16th July. Sorry, yeah, 16th July 2015. And finally, she's like my favorite relief ever, is an award of cost of his action against the defendant. And I think this is where the court now awarded the 3 million. I really do hope someone will share the judgment so I can actually properly go through it and be abreast of what really happened. But these are like, public information you'll find online if you do a Google search. Then, as usual, the defendants, which are Coca-Cola and NBC, denied that um, the work in question was not any a literary work that enjoys copyright protection. They also went ahead to say that for a work to be eligible for copyright, it must be original. So under the old that it was found under section 1 sub 2, um, where sufficient effort must have been expanded on making the work have an original character. I mean, for someone to think about creating a Ramadan timetable for breaking of fast, that shows you that it is original and that sufficient effort was put in. Kudos to Onile. Kudos to the guy who actually came up with this. I mean, it's not easy. So his name is Abdulmumineen Onilemarun. I apologize if I did not pronounce the name well. Please forgive me. But yeah, so they also the council representing Coca-Cola and NBC stated that there was no evidence before the court that the original work was published by the claimant, which they allegedly violated. I mean, every copyright lawyer or intellectual property lawyer know the basic when it comes to copyright. Copyright grants you automatic protection from the moment you transform or transfer your ideas into a fixed or tangible medium of expression, such as the calendar work that Abdulmumineen Onilemarun created. Come on. Anyways, they never even went to tell the court that they were granted a license. Now, under the former Copyright Act, what the law provided for, I think it was Section 11. Yes, Section 11. If it's a license and it's an exclusive one, it has to be in writing. If it's not an exclusive or non-exclusive where you can give several persons the right to use, in this case now, the Ramadan calendar for breaking of fast. By your actions, it can be implied by your action, it can be oral, it can be written. But if it's an exclusive license, such which I will assume this is it, then definitely that it should be in writing. Now, they stated that the claimant, who is Abdul Mominin Onilemarun, had given them consented or had given them the approval to commercially exploit the work and voluntarily assume the risk. What does that even mean? What does that even mean? Seriously. I mean, anyways. So, so we're still on to the case now. I think I'm just going to go through one of the publications. Then they concluded by stating that there was no agreement or contemplation or agreement for compensation because the calendar were not used for any economic purpose but for the educational purpose of the Muslim community during the time of Ramadan. Ah, I mean, even under the old act, we had under the second schedule there were provisions as to what would fall under non-commercial use, and then under the new act is found under section 20 of the act, and it's very detailed. For a brand like that, I don't think relying on that the calendar was for economic or educational purpose. I mean, it won't really fly. You guys can afford it, you know. And thankfully, the judge, listened to both parties and he raised only one issue, which was whether the plaintiff's claim of copyright has been proved to deserve protection and be entitled to relief. So he further held that Abdul Mominim Onilemarun suit, which is the lawsuit which he filed, is founded based on his literary work, Ramadan timing for dawn meals, for breaking or fasting for Kwara State. And he relied on the old act, section 20, section 51, which was the interpretation act to define literary works to include novels, stories, and poetical works, letters, reports, and memorandas, lectures, addresses, and sermons, and written tables or compilation. And he goes further to say, from the above definition, a compilation of the Ramadan timing for dawn meals, for breaking of fasting for Kwara State is a literary work, and I so hold. Now he goes further again to say that the NBC's argument and Coca-Cola's argument that the copyright that's you need a copyright certificate they said that the copyright certificate of the plaintiff, that is Abdul now, does not protect any literary work as none was submitted to the Nigerian Copyright Commission. So one interesting thing about the new copyright act that I actually like is that the words they used was a copyright owner may register their work. That's under section 84. Let me cross check. Let me verify that so I'm not misleading anyone. But yeah, what the law uses there is may. You may register your work. So their argument again is, I do agree with me, Lord, in this. So it goes to say, it is strike that registration of copyright is not a precondition to the protection of the copyright work, and then he listed the case which are hysterics. I was going to read later for my own personal review and education and research. And then he goes to say more so section 1 sub 2 paragraph A requires a party to prove that he has expanded effort into the work, etc., etc., etc. So in conclusion, Coca-Cola and NBC Sha paid the guys 3 million. I mean, I have a couple of colleagues who had stated that the sum was little. I mean, I would always tell people that when you have a matter in court, it's how you present your case. And when it comes to computations and court giving their verdict on what the court is basically not Father Christmas. It's not Santa. He is not Santa. You get it? Yeah. So another section that Milord relied to under the Old Act for Section 6 Sub 1 Paragraph A Sub 1, which talks about the exclusive rights entitled to a literary work. Now, what I'm going to do going forward is do a comparison of what the old Copyright Act provides in terms of the bundle of exclusive rights for literary work. And if you look at this case, three rights were highlighted, which is the right to reproduce a literary work, the right to distribute a literary work, and the right to actually publish a literary work. Now, for my own evaluation, I highlighted four areas that I would be reviewing. The first one is copyright infringement. The second one is breach of confidence or secret information in the making of accurate Ramadan timetable. Number three is infringement of substantial similarities of his method and the copyrighted work. And finally, sharing of 40% of total profit made by NBC and Coca-Cola in Kwara State between June 2014 and July 2015. So I'm going to start with saying that one thing I do like or appreciate about the new Copyright Act 2022 is that now the law clearly states that you do not require any kind of formality for your copyrighted work to be eligible. Now that that has been clarified and we've identified that the Ramadan calendar falls under the literary work, which is an eligible work under the Copyright Act, both the old act and the new act. We're going to proceed to look at the bundle of exclusive right. Now, if you recall, previously I stated that under the old act, you could find that under section 6 sub 1 paragraph A. Now, we're going to focus on three, which is the right to publish the work, the right to distribute the work, and the right to actually reproduce the work in any material form. Now, under the new Act of 2022, what the law states is for copyright in literary work, you shall have the exclusive right to do and authorize the following. So you see that consent, permission, and authorization is very important. You really cannot do away from it because it imposes some sort of obligation at the general public to exclude the copyright owner or to exclude the general public from exercising any of those acts that are restricted to just the copyright owner. And this is where a copyright owner will get his power to, or as a basis, to commercialize and exploit their creativity, such as licensing, which NBC and Coca-Cola had alluded to that they had gotten, which in reality they never did. Now, same thing for section 9. You also say to reproduce the work, to publish the work, and then distribute the work to the public for commercial purposes, copies of the work through sale or other transfer of ownership, provided the work has not been subject to distribution authorized by the public. Now, if you have seen the carousel which I created, I went as far as making or doing an explanation on what will classify or fall under, or the explanation on these exclusive rights that I listed in my presentation. So let's start with the simplest one for me, which is the right to, just hold on guys, which is the right to reproduce. Now that right gives you the opportunity to make copies or recording of a work in a way such as photocopying or scanning. Now I wish that because of the publication they had shared how NBC and Coca-Cola had reproduced the calendar. Then right to publish gives one the legal authority to actually publish copies of the work, which only pertains to the initial placement of a copy in commercial circulation. And finally, right to distribute is the right to rent or lend copies of the work to the public, which Mr. Abdul had stated that NBC and the Coca-Cola was responsible was responsible for rather. Now let's move on to licensing. Yeah, licensing was stated. Now under the old act, when you talk about licensing, yeah, the law provided for them stated that an assignment or testimony disposition of copyright may be limited to as to apply to some of the acts. So even when you are assigning your license, your rights, you're not giving the person the right to actually um, do perform all the rights such as the right to republish, to reproduce or distribute. You're just giving them some. So in this case, if Mr. Abdul um, opted to give opted to give his consent to NBC and Coca-Cola, it would have been, oh, you have the right to publish this to the public or distribute it to the public or to reproduce, as the case may be, not all of that bundle of exclusive right. Now, exclusive right under the new act is defined as a license signed by or on behalf of a copyright owner authorizing the licensee. Now, the licensee in this case would be NBC and Coca-Cola, to the exclusion of every other person, including the person granting the license, to exercise any right which would otherwise be exercisable exclusively by the copyright owner. Whereas a license is defined as lawfully granting license permitting the doing of an act controlled by this act. Now, under the older section 11 sub 3 says that no assignment of copyright or no exclusive right to do an act shall be controlled by copyright, or doing of that which is controlled by copyright shall have effect unless it's in writing. So if they were claiming that Mr. Abdul had as licensed the Ramadan calendar, it had to have been in writing, else it's not binding and it has no effect, as we have seen in the old act. Whereas under section 30, which talks about assignments, yeah, it talks about assignment and licensing. It states that for the purpose of Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999, it's very important that as Nigerians, we need to be abreast with what the Constitution provides. And under that, it states that copyright shall be deemed to be a movable property and shall be transferred by way of assignment, testimony, disposition, or operation of the law. And as we can see from what we've seen online, anyways, that wasn't done. Similar provisions under Section 30 sub 3, as I read in Section 11 sub 3. Then sub 5 states that, okay, this is with co-owner relationship. Sub 7 states that ownership of a material in which a work is embedded shall not confer ownership of copyright in the work, except as may otherwise be provided for in an agreement. An owner of copyright who transfer the ownership of the material in which the work is embodied shall not be deemed to have transferred his copyright or to have granted a license for the exploitation of his work. Except as may otherwise be provided for in agreement, an owner of copyright who transfers his copyright or grants a license for the exploitation of the work shall not be deemed to have also transferred the ownership of the material in which the work is embodied. Now, sub 10 of section 30 of the Copyright Act now states that an assignment or license or testimony disposition may be granted or made in respect of future work or an existing work in which copyright does not subsist, provided that it shall not be permitted to transfer the rights in all future works of an author. I hope that makes sense. Yeah. So I was also going to look at um, compulsory license and and produce translation. But I don't think this required any form of translation. So I'm just going to go to section 29 of the new act, which talks about ownership of copyright of collective work. No, I shouldn't be doing that. Rather, section 28, yeah, we talked about first ownership of copyright. Now it states that unless it was provided in an agreement, copyright shall be conferred by this act initially to the first author, which an author as defined under the interpretation section will depend on the type of intellectual property in this case. Then one thing I was going to look out for is the right to claim authorship, um, which section 12 of the former act stated that the author of the work shall have the right to claim authorship of his work, in particular that his authorship be indicated in connection with any of the act provided for in section 6, except where the work is included incidentally or accidentally when reporting current event by means of broadcast. And this was no current event, you know. Um, they also have the right to object and to seek relief in connection with any distortion, mutilation, or other modification, and any other derogative action in relation to this work, where the work would be or is prejudicial to his honor or reputation. And it goes further to state that this law, the rights are perpetual, inalienable, and imprescriptible. So let's look at what the provisions of the law is now on authors' moral right. So under section 12 of the former act, it was like merged together. But under the new act now, um, they distinguished it. So the bond of exclusive right, which we talked about for literary work under section 9, will focus on the economic right, which gives a literary work owner the right to commercialize or exploit his work for economic benefits, such as the right to reproduce, the right to publish, the right to distribute. And I'm focusing on these three bundles of right because this is where the alleged infringement that or the infringement that NBC and Coca-Cola carried out. Whereas moral right gives you the opportunity to claim authorship of the work, um, to object and seek relief, which is kind of similar to what Section 12 of the Act stated. Then it goes further to say a person has the right to object toward being falsely attributed to him as the author. That wasn't provided for in the former act. Then it goes further to also states that the right conferred here shall not be transmissible during the life of the author. That wasn't also provided for in the former act. So you cannot transfer your moral rights as long as you are alive, and even upon your death, it can only upon the death of the other be transmissible by testimony disposition or by operation of law, so a will in this case. The rights conferred on this shall be subject to the duration of the copyright in the work, which wasn't the case. you know it wasn't the case under the old act. Section 12 sub 2 states as the rights referred to in subsection 1 are perpetual. Whereas under the new act now, this moral right will last for the duration of the copyright. So copyright for literary work um, lasts for the lifetime of the copyright owner plus 70 years after, you know. Then um, let's talk about the right to share in proceeds of sale. I don't know because I want to start from the list and then build up to like my highlight, which is the breach of confidential information. So let's discuss how a copyright owner can share in the proceeds of sale in the event where you decide that you want to sell your copyrighted work. What did first of all the old Copyright Act provide? And the old Copyright Act listed a couple of things. It said, notwithstanding any assignment or sale of original work, the author, all graphic works, three-dimensional works, and manuscripts shall have an inalienable right to share in the proceeds of any sale of that work or manuscript by public auction or through a whatever the method they used by the latter to carry out the operation. And the right conferred in this section shall apply to originals of such work. And it goes further to state that the conditions for exercise of right conferred by it shall be determined by regulation made by the Nigerian Copyright Commission as established under, you know, Section 34. Then it goes to state it shall not apply to architectural work or apply that, and this calendar is not an architectural work and neither is it an applied work. Now, under Section 17 of the new it's similar, but then what caught my attention is that while I was listening at the work is stated sale of original work, an author of an artistic work, manuscript of a literary work. So would you say or would you consider Mr. Abdul's calendar of the Ramadan tables to be a manuscript of a literary work? Think about it, guys. Really think about it. It also goes to state that they shall have an inalienable right to share in the proceeds of any sale of that work or manuscript by public auctions or through a dealer. How do you then calculate profit made from an unauthorized use of a copyrighted work, such as the literary work in our case study? First, you will determine the profit that was generated from the unauthorized use, then subtract the cost that is associated with the use to be able to arrive at that mathematics. So if you thought that as a lawyer you're escaping maths at any point, trust me, you will not escape maths because there's certain areas of law that will require some sort of calculations that you need to do. Now there's no definite formula for calculating profit. However, there are certain possible ways that can be used to determine um, how we can arrive at this. And first is to calculate the actual damage suffered by the copyright owner as a result of the infringement. And I say this because of the conversation I had with a colleague on a WhatsApp platform when I shared my views about this case. And what's the comment again? Something about how the judge wasn't fair. And I had to let him know that one like you need to really consider what was the actual damage that the copyright owner really suffered. If Coca-Cola had not used Abdul's work, how much would he have made within that time frame in 2014 June and also in 2015 July? Another way would be to calculate the profit earned by the infringer from the unauthorized use. This will include the gross revenue minus any deductible expenses that the infringer can prove. So you see that other than making your request in your reliefs, you need to show and prove to the courts that you actually deserve the profits that you are claiming. Another way would be to calculate the statutory damage um, as the case may be. If whether you need to also take into consideration whether the infringement was willful, innocent, you know, on all of those things. Another way is to calculate the profit from an infringement. Um, the actual amount of damages awarded in a suit may vary depending on the facts and circumstances of each case. I hope that makes perfect sense for all my IP friends listening to my conversation today. So I'm just going to add a couple more things with regards to calculating your profit. Now, we're going to talk about the difference between actual damages and statutory damages, especially when you are the owner of a copyrighted work and you're going to be asking the court for some reliefs. So, the difference is that actual damages are like the real losses, what you actually lost or what you suffered as a result of, in this instance, Coca-Cola and NBC's use of your work. Whereas for statutory damages, there's like a fixed amount of compensation that is determined by the law. And actual damages can be divided into economic damages and non-economic damages. I hope this is not too much jargon for my listeners, but let's delve into that conversation too. So, economic damages are the financial losses that can be calculated and proven, such as property damages. Whereas for non-economic damages, they are the intangible losses that are harder to measure, such as pain, suffering, emotional distress, and loss of quality of life. And as a copyright owner, I'm sure that just being in court already with a loss of adjournment date, as the case may be, and waiting for the final day when the judge will give his judgment, it might be a little bit stressful for you to deal with. Then for statutory damages, they are awarded in cases where, hold on, my laptop is giving me issues. Okay, where were we? um, so for statutory damages, they are awarded in cases where actual damages are difficult to prove or insufficient to deter future violation. They are often set by the statute or the law and do not depend on the actual harm and loss caused by the defendant. They are also common in areas such as intellectual property, consumer protection, disputes, etc. For in an instance where it's a copyright infringement suit, the plaintiff, who in this case is Abdul, can choose to recover either actual damage or statutory damage. Actual damage could be as a result of loss of sales or licensing revenue, and I think licensing revenue would definitely apply to Abdul's case because Coca-Cola and NBC were alleging that he had issued a license to them, though not in writing, which is weird. Um, and as a result of that, he has lost some money. Um, I hope this helps you understand the difference between actual and statutory damages. If it doesn't, you can always send me an email to ipseriesinfo@gmail.com or my DM at ipseries underscore with underscore esmeraldo esq. Now, the next thing I'm going to be sharing is who actually has the right to share in the proceeds of sale for a literary work. Now, that would depend on ownership of the copyright work. Ownership can also be determined where, depending on your contract, if there is a written contract that can help determine whether or not you own a copyrighted work. Then you now determine the kind of relationship. Was it a work for hire? Was it an employment arrangement? Were you commissioned? So I'm trying to get to the section of the law that is under the new Copyright Act. Because under the old Copyright Act, what is stated under Section 10 is that first, it says copyright shall vest in the initial author. that is established already. However, if you were commissioned by a person who's not the author's employer under a contract of service or apprenticeship, or you were not so, or not having been so commissioned is made in the course of the author's employment, the copyright shall belong in the first instance to the author unless otherwise stipulated in writing under a contract. Then sub 3 goes further to state that where a literary, artistic, or musical work is made by the author in the course of employment by the proprietor of a newspaper, magazine, or similar periodicals under a contract of service or apprenticeship, as is so made for the purpose of publication in newspaper, magazine, or similar periodical, the said proprietor shall, in the absence of any agreement to the contrary, be the first owner of the copyright work, insofar as the copyright relates to the publication, you know, long conversation. But now let's look at what the new Copyright Act talks about in terms of authorship. Um, just give me a few seconds. I am close. Oh, I thought I was getting close, but it kind of feels like I'm far off. But hmm, mm-hmm, mm-hmm. Okay, okay. I'm still trying to get to the section that talked about. What was I talking about again? Yeah, what's created in the work of employment. Mm, why is it that it's when you actually need something that you start to, you know? So work in this case will also include literary and artistic work in the form of text, notation, or related illustrations that are available. Mm, yeah, that's under section 28 sub 2 of the Copyright Act of 2022. It says when a person, in the absence of an agreement to the contrary, creates a work under a contract of service. So it's kind of similar, but it then goes ahead to expand it. It says, or the person is in the course of an employment by a government, a ministry, department, or agency or government of a prescribed international or intergovernmental organization. The copyright in the work shall vest in the government, ministry, department, agency, prescribed international or intergovernmental organization. Top 3 stated that subject to subsection 1, which talks about who the original author will be, and subject to any agreement between the parties, where a person for private or domestic purposes commissions the taking of a photograph or painting or drawing of a portrait. I don't think this applies, but I'm just going to read it anyway. Or the making of an audio visual work. The person who commissioned the work shall be deemed to have a non-exclusive license to exploit the commissioned work for non-commercial purposes and entitled to restrain the publication, exhibition, broadcasting, communication, distribution, and making available of copies through the public. Inano, I hope you guys got that part right. Yeah, so moving on. I think I've kind of like talked about everything with regards to profit sharing. I'm going to move on to my star conversation, which is on copyright protection for confidential information. I thought I was going to do that last, but I think before we get there, let's just okay, whatever. Let's talk about it. Yeah. So for me, the style of this conversation is not even about the copyright infringement argument or case, but the fact that one should consider protecting their confidential information. Now, what is confidential information in this case? Confidential information is any information that is not, you know, in the public domain and has value, commercial value, or potential commercial value to you. Um, about your business, your customer, your finance, your personal life, that if it gets in the wrong hands, it can be misused. It can also be stolen by someone who has ulterior motive. It can also be leaked by others who want to harm you or feel like they can benefit from that information getting into the public. So you need to take extra precautions and measures to protect your confidential information um, by appropriate means. While breach of confidence would occur where a secret information um, where a secret information which is supposed to be private um, may have been shared, disclosed, or communicated to someone, in this case, Coca-Cola, and they ended up using it for unfair advantage to do, which will now give rise to a civil claim. Civil claim now is what we are now discussing as, I beg your pardon, as our case study. Now, what are the ways that you can protect your confidential information? I think it will also depend on the type of information first, the nature of the information. First one would be contract. I mean, a lot of people may shy away from contract, but okay, let's redo that list. For me, is once you've identified that your work has commercial value, I would advise that you consider do like an evaluation to determine the type of intellectual property right that exists. So let's say you're considering patent. Patent for your confidential information can be related to your inventions, your product process method. It also gives you exclusive right for a term of 20 years to use, make, sell, and import those inventions within a particular jurisdiction. Patent can also prevent other people from copying, imitating, or reverse engineering your invention. Then you have trademark. You know that registering your trademark for your confidential information can relate to your brands, such as the name, logo, slogans, or design. It can also give you the exclusive right to use or license your brand for certain goods or services. It can also prevent other people from using confusingly similar or identical brands that may cause consumer confusion or dilution of your brand. It also needs to meet the basic requirement of being capable of distinguishing and being distinctive. Whereas for patents, it must be new, novel, not obvious to a skilled person before you start talking about contracts. I mean, that's the hierarchy for me, anyways. Now let's go back to contract. Now with contracts, you would have to, need to have all the parties consent to actually getting into a contract. There must be offer and acceptance. So you've offered, say, an employee, you've got to make a pitch to a supplier, to an investor, or it's with regards to your customer. Your contract must specify the terms and conditions of using your confidential information. I had a very funny experience recently. I'm supposed to be sharing confidential information, but the other party thought it wise that it'll be best for them to send me an NDA to sign. And I was wondering, I don't know what do you guys really think? I mean, I kind of came off like it was like a red flag to me. So, well, I haven't really decided what I'm going to do about that situation. But confidential information would, you know, when you're talking about the terms of control, we talk about the confidentiality, how important it is that it should be kept a secret. You cannot use, non-use. You cannot disclose, and you cannot compete with that person. Although certain jurisdictions in the US are contesting this non-compete clause, because they feel it kind of restricts, what's it called now? Creativity, you know. And the contract will also go ahead to provide remedies in the event of a penalty for breach of contract, such as damages, injunction, or termination. Now, when Abdul sued, one of the reasons or grounds was breach of confidence. Yeah, so he was also suing them for breach of confidence. I'm trying to get, yeah, so 10 million naira for breach of confidence of secret information and secret idea, which the court, based on available material, never alluded to, which then reminds me of the Google Oracle case that started off as a patent case but ended up as a copyright case. So I really don't know. I mean, in the publication, it never said anything about the court considering this angle. I wish if you have, and someone can just share the judgment with me so I can, you know, be properly guided on what the court really did. But that's about it for contract. Now, what type of contract will it be? A non-disclosure contract. Sometimes you might see a non-disclosure clause, but when it's a proper document, um, named or titled non-disclosure agreement, you now have to sign that agreement with people who will receive that information or may have the potential of using that confidential information, such as potential investors, like in this case Coca-Cola, buyers or collaborators. NDAs help you define what constitutes confidential information, how long it should be kept, confidential, what are the obligations and restrictions of the parties. It also provides remedies and penalties for breach of NDA, such as damages, injunction. But then it also has limitations. What are the limitations and challenges? For instance, contracts and NDAs may not be enforceable in some jurisdiction or situation. They may also be difficult to monitor or to prove in case of breach. Patent may not be granted for some type of invention and may be challenged by others for validity or infringement. It may be expensive and time consuming to obtain and maintain as well. Trademark may not be registered for some type of brand or may be challenged by others for validity, infringement, non-use. Um, what's the other one? They may also be subject to fair use or parody. I think I'm going to allude to the um, dog toy case between Jack Daniels. I did a podcast, a carousel, and a tweet about it, so you guys can please check it out. Just to be abreast. So you need to choose the best way to protect your confidential information based on specific circumstances and need. You may also need a combination of different ways to achieve um, a foolproof protection. You also need to consult your lawyer, not just any lawyer. Consult your um, intellectual property lawyer, an expert, before making any decision regarding confidential information. So, what are those? Sorry, guys. What are those elements? Hold on, my laptop is acting up again. Right. So, what are those elements in an action for elements of an action for breach of confidence? First, the information must be confidential in nature. Very important. And there must be an obligation of confidence that has been um, determined by either a reasonable person test and limited purpose test. And hold on. Okay. And you will also be considering finally you will also be considering unauthorized use of the information if it's going to be an actual or threatened danger or threatened disclosure of the work in question. We're going to move on to what is the difference between. I think I was going to talk about that, but then briefly, how do you then deal with a breach of confidence? You need to identify and get evidence that your confidential information has been breached. Yeah. Then you need to also consider the thought of undisclosed information via thought of conversion, which is like the act of dealing with goods in a way that it interferes with the owner's rights to use and control the goods and doesn't need to be aware that the goods belong to someone else. Um, e.g., changing the nature of the goods or taking possession, making it impossible for the owner to exercise the rights, that's the IP right, uh, IP right of possession, or using the person's goods without their permission, as we've seen in this case. And one of the things that the court will consider is the intention of Coca-Cola to deprive Abdulmumineen of possession or control of his work, and the remedy they are entitled to will include damages. Now, Abdul will also be required to show that the misuse of the private information shared with Coca-Cola, as he had a reasonable expectation of privacy. Now, what would be Coca-Cola's and um, Nigerian bottling company's defense? One, that the information was not confidential enough. Does it make sense? And that they had gotten the consent of Abdul. I think they alluded to that they got his consent to use his work and commercialize it, and that he had given them a license. So, then they also need to disclose that they had to disclose it due to a legitimate public interest, and that the information was already available in the public domain. And then finally, with regards to this whole breach of confidence conversation, Abdul will be entitled to an injunction against Coca-Cola and NBC, damages and destruction, compensation, delivery of, and account of profit. Isn't that fantastic? And don't you also find this conversation on breach of confidence really, really insightful? Please let me know what you think. So, my next line of conversation, I'm going to merge both the infringement of substantial similarity of Abdul's method in the copyright work, and also um, infringements under both the old act and the new act. So, under the old act, section 15 stated that infringement of a copyright would be where someone who, without the license or authorization of the owner of the work, does or cause any other person to do an act which is controlled by copyright, exhibits in public, distribute by way of trade, offer for sale, hire. Let's see now. So I'm going to refer to those which I think alludes to our conversation. Then I also want to point out this section. I kind of stumbled upon it while I was, talking about infringement. So that's section 43 of the new Copyright Act 2022. It said in an action for infringement of copyright in a work, whether civil or criminal, the following action shall be presumed where such work has been registered under section 87 of the Act, that the copyright subsists in the work, which is the subject matter of an alleged infringement, that the name appearing on the work purporting to be the name of the author is the name of such author, that the name appearing on the work purporting to be that of the publisher or producer of the work and the name of such publisher or producer. Now, in an instance where the author is dead, that the work is an original work and that it was published or produced at the place and on the dates appearing on the work. Incredible, right? Or would I say insightful? Right. So one thing again that I would say I really like about this new act is the fact that it really expanded most of the sections that were not so broad. So for instance, we're talking about infringement that are actionable as a breach of statutory duty. Um, it states that the person whose right has been infringed upon shall be entitled to an act of damages, injunction, or any other remedy as the court may deem fit. Then the right of action under section 39 provides that notwithstanding the provision of this act or any law, no action for an infringement of copyright or any right under this act shall be commenced or maintained by any person or organization who engages in the business. Oh, sorry, I'm reading on the okay, yeah, limitations to the right of action. So if you engage in the business of negotiating or granting of license, this act applies to you as you are permitted. You're not permitted to commence any infringement act lawsuit. If you also collect and distribute royalties in respect of copyright work, or if you represent 50 owners of copyright. So this is more or less like for CMOs. So let's go. into the one that really focuses on an action for infringement, which, if you read side by side by section 15, it's a bit, let's say a bit, is really detailed. So let's look at section 37, an action for infringement. It states, subject to the provision of this act, infringement of copyright shall be actionable at the instant of the owner, assignee, or an exclusive licensee of the copyright in the court exercising jurisdiction in the place where the infringement occurred. So this case happened or took place in Kwara State, and NBC and Coca-Cola were neither a licensee, but Abdul, in this instance, is the owner of the Ramadan timetable. Secondly, it stated, in the action of an infringement of copyright, the plaintiff shall be entitled to reliefs such as damages, injunctions, accounts, or as is available in any corresponding proceedings in respect of infringement of other proprietary rights. Now, sub 3 states that when an action for infringement of copyright is brought by the copyright owner or an exclusive licensee relates to an infringement in respect of which both have concurrent rights of action, the copyright owner or the exclusive licensee may not, without the leave of court, proceed with the action unless the other person is joined. Sub 4 states, in an action of infringement of copyright where it is proved that there's an infringement, that infringement was actually committed. By the time of the infringement, the defendant was now aware or had no reasonable grounds to suspect that copyright subsisted in the work to which the action relates, the plaintiff shall not be entitled to indemnity. So, if the defendant come and say, I was not aware that then this is not, this is a copyrighted work, nothing for you as a plaintiff. So you need to do your due diligence to confirm that the defendant is actually in the know. Now it goes sub 5 states that an action for an infringement of copyright is proved or admitted, and the court in which the action is brought is satisfied that the effective relief would not otherwise be available to the plaintiff. The court, in assessing damages for the infringement, shall have the power to award such additional damages as the court may consider appropriate in the circumstances, having regard to the flagrancy of the infringement and any benefit shown to have been accrued to the defendant by reason of the infringement. I think this is something that, if this case took place within this period that the new Copyright Act was enacted, I think the court would have considered this section while making its judgment. And in any proceeding for infringement of copyright, no order shall be made which require a completed. Okay, this doesn't really apply. This is for like completed and completed B, but it doesn't really apply. Now, one other section again that stood out for me, because I'm an arbitrator and also an ADR practitioner. Sub 7 states, any dispute arising from the exercise of a right under this act may be subject to arbitration and may be resolved by any means agreed to by the parties to the dispute. Why am I excited? We now have a new arbitration and mediation act, and it is also another detailed document that creatives should pay attention to. I know in one of the definition clauses it talks about what a commercial dispute would be, and intellectual property was listed as an example of what a commercial dispute comprises of. Then top 8 defines what an action would include. Said an action in this section, an action includes a counterclaim and reference to the plaintiff or the defendant shall be construed accordingly. Fantastic provision. Similar to section 15 as well, infringement of an act without authorization. You do, of course, any act to be done. You sell, offer for sale or hire, permit a place of public entertainment. You know. So one thing I noticed is that while the former act talks about distribute by way of trade, this section doesn't really mention. That's section 36 of the Copyright Act 2022 doesn't talk about distribution here. What it talks about is doing of an act, sell, offer for sale, make or has in his possession, imports, permits a place of public entertainment, permits within its premises reproduction of a copyright work, performs. Then it goes further to say that the doing of any of these acts in session shall be in respect of the whole or substantial part of the work, either in its original form or in any form recognizably derived from the original. Now, here is my copyright tips for corporates or directors. So, under section 46, sub 3, it defines a body corporate to be either a firm or other associations of person, and a director to be in relation to a firm, which includes a partner in the firm. Now, looking at Coca-Cola, let's analyze how offenses by an offense, a copyright offense by bodies corporate, how the law will look at it. First, where under section 46 sub 1 states that where an offense was committed by a body corporate, the body corporate and its principal officers are deemed to have committed the offense as well, and they're also liable to be proceeded against and punished accordingly, provided that nothing contained in this section shall render any person liable to any punishment if he proves that the offense was committed without his knowledge or that he exercised due diligence to prevent the commission of the offense. Then subsection 2 states that where an offense under subsection 1 has been committed by a body corporate and it is proved that the offense was committed with the consent or connivance of any director, manager, secretary, or any other officer of the body corporate, such director, manager, secretary, or other officer shall be deemed to have committed the offense and shall be liable to be proceeded against and punished accordingly. So, while you may be suing NBC and while you may be suing NBC, it will also be in your best interest to consider suing the directors or manager or secretary, because if they were actually aware of the offense, then they should be held liable and not just the company. I mean, someone has to be held liable. But then again, that will also depend on what the person signed, you know. So, yes, I'm just trying to confirm that we have a definition of what qualifies as an offense. Oh no, it doesn't. So what sub 103 states that the Federal High Court has or shall have exclusive jurisdiction for the trial of offences and civil action arising from this act. You know. Yeah. So that's like my free tip for body corporates like embassy and managers and directors and secretaries and firms. Yeah, before I conclude. So to conclude our conversation, if you are a body corporate such as NBC or Coca-Cola, and it's been found that you use a copyrighted work without authorization, consent, and permission in Nigeria, you may face both civil and criminal consequences, and your officers may also be held personally liable if they were involved in the infringement. Now, one other beauty about this case is that it's going to show the relationship and interplay of copyright protection of confidential information, which both enjoy automatic protection from the moment they are created, and also the fact that copyright owners must secure their intellectual property rights by exploring security measures such as encrypted password encryptions, password access control to safeguard their works by relying on the technological protection measures as provided for under Section 50, Sub 1, which reads as follows. No person shall knowingly circumvent a technological protection measures that effectively protects access to a work protected under this act. Now, sub 3 reads as follows. So sub 3 defines what a technology protection measure should be, which means a technology device, a product or component incorporated in the work which is designed to effectively prevent or inhibit the infringement of any copyright or related right. While circumventing a technological protection measures will mean you using means to avoid or bypass or remove, deactivate, decrypt, or otherwise impairing a technological protection measures. Now, sub C of section paragraph C of subsection 3 states that a technological protection measures effectively protects a work under the act if the measures in the ordinary course of the operation controls access to the work provided under the act or prevents or restricts acts in respect of the work which are not authorized by the author. Remember that copyright owners enjoy a bundle of exclusive rights, and it's only when they give you the consent via a license on assignment or maybe they sell it that you can exercise those rights. So if you're not authorized by the author consent or permitted by law, whereby the Copyright Commission might step in depending on whether there's a special provision because you own, say, a museum, a gallery, or a visually impaired person, then this section does not extend to those measures which in normal course of operation only control access to work for non-infringing purposes. Then sub section 52 sub 1, hold on, I think I just missed it. Yeah, 62 sub 1 says that a person whose right is violated under section 50 or 51 may institute an action before a court of competent jurisdiction, which in this case is the Federal High Court, to seek redress for damages, account, or injunction as are available to a plaintiff in any similar proceeding in respect of infringing of other proprietary right. Yeah. So one other thing that I also failed or forgot to allude to in the course of my conversation is with regards to after you've discovered that there's an alleged infringement or violation of your work, and the distribution of the profit may rely on whether or not the work was used in a particular situation in accordance with the fair dealing standard, depending on the following principles. So the fair dealing standard can be found under section 20. Yeah, it needs to be found under section 20. So I'm trying to get there so I can read it for you guys. You know, to you properly guided. Yeah, I'm here. So section 20 talks about exceptions to copyright. So you have the general exception, which is that um, under the Act, for all the eligible works, in respect of the work, it does not include the right to control any of the acts specified by way of fair dealing for purpose such as private use. So Coca-Cola needs to show us whether the use of the Ramadan was for private use. I mean, it wasn't, right? Was it for parody, satire? Was it caricature? Pastiche? Pastiche. Here. Forgive me, I beg. Criticism, review of the reporting of current events. I mean, they weren't reporting any current events, so no. Subject to the condition that if the use is public, it shall where practicable be accompanied by an acknowledgement of the title of the work and its author, except where the work is incidentally included in the broadcast. And that was not the case here. They never for once acknowledged Abdul's contribution in the creation of the calendar. Now it goes further to say that provided that in determining whether the use of the work in any particular case is fair dealing, the following factors such as the purpose and character of his usage, of the Ramadan timetable for breaking a fast, the nature of the work, amount and substantiality of the portion used in relation to the work as a whole, and effect of the use upon the potential market or value of the work. So this can also be categorized or considered when you're talking about how you calculate profit made from an unauthorized use of a work. Mhm. I hope that makes sense. Yes, it does. I mean, then my next contribution would be that the party whose copyright and confidential information was shared without consent can apply for either. So the party who the copyright and confidential information was shared to can apply for either an exclusive or non-exclusive license to use the work in question, but that never happened in this case. Instead, they were stating that Abdul actually gave them a license, which is kind of weird, not true as well. Then the IP owner can use copyright to protect to protect his confidential information and also reproduce, publish, distribute, as we saw in this case today. So another recommendation for me would be that IP owners and copyright owners can also consider copyright registration as provided for under section 87 sub 2, which states that a person may apply in the prescribed manner to the commission to register a work that is eligible as provided for in section 2 under the act, and then sub 4, which kind of collaborates. Why you need to do that is that the register shall at first instance be evidence of the work and the particulars entered in the register, and may extract from the register certified by the commission shall be admissible in evidence in all proceeding without further proof or production of the original. So if someone is doubting the originality of your work, you just need to go to Nigerian Copyright Commission and get a certified copy to prove that this is the original. You know, so I think that's kudos, or that's a well uh, introduced provision. Then you can also tap into the value of your intellectual property, which gives a creator the rights, which gives you values such as market exclusivity, opportunity to sell, opportunity to buy, opportunity to license, and also enhance the commercial value of your work that you've created. Copyright owners must also be proactive in protecting their rights by identifying um, what can help an IP owner in this digital era by incorporating smart contracts, exploring technological protection measures, which I talked about earlier, timely registration of the work. You need to also monitor the marketplace by using IP lawyers or experts or law firms or companies that have been set up to help IP owners to manage and monitor their works in the market. You can also explore takedown proceedings or border enforcement, you know, for counterfeited literary work or pirated literary works, as the case may be. You can also opt to send a cease and desist letter. Because I haven't seen the judgment, I don't know. And also, the publication did not state that Abdul's lawyer had sent a cease and desist letter to Coca-Cola as well. You can take legal proceedings such as litigating, and also alternatively sensitize the public or your consumers about your work. Alternatively, you can sign an NDA or non-complete agreement, but make sure that you have completed the registration of your copyrighted work or intellectual property. Then finally verify the information sh- and verify that the information shared is in compliance with data protection and privacy laws of Nigeria. See section 26 and section 30 of the Data Protection Act 2023. So one good thing again that Buhari did for us was signing relevant law, and also President Tinubu as well. I mean, and still giving kudos for, you know, all the signings he had been doing. But I'm just trying to draw up, yeah, trying to bring up the Data Protection Act to read section 26. 26, we talk about the consent that you need from the data subject in question, and also, um, hold on, and also, okay, this is taking me a lot more time than I anticipated, but we are here. Yeah, and then section 30 talks about sensitive personal data. So, those information that you share, do you consider them to be sensitive personal data that you shared with a third party such as Coca-Cola? So, reading section 26, it says a data controller shall bear the burden of proof for establishing a data subject's consent. Um, in determining whether the consent was freely and intentionally given, account should be taken of whether the performance of a contract, including the provision of a service, is conditional on consent to the processing of personal data that is not necessary for the performance of the contract. Silence or inactivity of the data subject shall not constitute consent. Now, why this kind of stood out for me again was I think it's about the I read one case anyway. I saw a video about it where, it was assumed that silence meant that the person agreed to the contract, and it was a shame. I don't know. But subsection 7 talks about consent shall be affirmative and not based on pre-elected confirmation, and may be provided in writing, orally, or through electronic means, while Section 30 of the Data Protection Act 2023 talks about sensitive personal data. Sub 1 reads, without prejudice to the principles set out in this act, a data controller or data processor shall not process or permit a data processor to process on his behalf sensitive personal data unless the data subject has given and not withdrawn consent. So why I'm alluding to this is the fact that copyright or intellectual property relies solely on consent. And without consent, you really cannot do much. Without consent, you can't do much. You need consent to be able to progress, um, and also to make impact within the creative space. You can't exclude the general public, but then you have the final say on how you can address questions as to whether the basis identified could be in relation to, an express copyright license that can legitimately be the basis for engaging in the process of implications of copyright um, licenses. Um, Again, a copyright owner's power to consent is um, gives the copyright owner the right to act out on their own volition in relation to the copyright work. It's also their source of power to enable them give that consent that is being demanded for, as long as they are the owner of the copyright work in question. So, yeah. And so if you're reading that section, just focus on subsection 1 and all its provisions, and that's it. So I want to thank all my IP friends for tuning in to listen to this episode. If it's long, I apologize, but I had to do it. I do hope that you enjoyed and you learned something new. If you have any comments or questions, please feel free to contact me via our email ipseriesinfo@gmail.com or at ipseries_with_esmeralda_asq. We're also on Twitter at ipseries1, also on Instagram, or on Facebook as well. And don't forget to subscribe to our podcast for more episodes on intellectual property law and practice. Until next time, stay safe and stay creative. Goodbye.